gonna be joyful today. Got the joy down to my heart, down to my heart, down to my heart. I got the joy down.
Hi everyone, I'm constitutional attorney Catherine Henry, and while we're giving people a second to get the notifications that we're going live, I want to listen to this really great song that just happened to come on. And unfortunately I caught it too late. So with that being said, all right. I'm still going to go a little bit slow to make sure people have a chance to catch on to our live here and join us. So I will reiterate, I'm constitutional attorney Catherine Henry, and I'm coming to you live today to give you some information that, quite frankly, isn't new. Thousands of you have heard this information from me before, maybe once, twice, 20 times. But it's information that nonetheless, I'm still continuing to get calls, emails, text messages about. I'm still having countless people ask me personally, or when they see me in person, or in all kinds of scenarios. People that have known me for years, people who I know have heard me speak on this topic. And it tells me not that those people are unintelligent, but it tells me that this is a topic we need to cover again. So good for me. I actually didn't erase this board that I wrote in October last year. So I will be utilizing that again, as well as another board that seems to have not as much on it, but it's been, quite frankly, just as important. And my goal will try to be to bring information about the MDHHS mandates, which are here in Michigan, but quite frankly, the parts about the US Constitution that I'm referencing and the general concepts of government apply the same to every single state in the US. So if you are in Florida or in Nebraska, or if you're in Wisconsin, you'll still be able to get something out of this presentation. So with that being said, I do want to, I love it, Rachel. Rachel says through YouTube that this wonderful board is a screenshot on her, is saved as a screenshot on her phone. And you know what? Wouldn't be bad to have as that backdrop that you can see every day and glean a little bit more from every day as you look at your phone. We all look at our phones way too much these days. So, okay, so there's some new things I wanted to share. Not really new, but new in the context that I might not have specifically talked about in the last time I talked about this board. So, number one, well, I'm gonna back up a minute. What are we talking about? What kinds of questions are people having? I can guarantee you that of all of you now watching, and those of you to watch later on, that at least half of you, if not 3/4 or more of you, have had these questions even recently. So I will reiterate that the kinds of questions I'm talking about dealing with right now are dealing with contact tracing, microchipping, the COVID or even the flu vaccine, masks, social distancing, temperature checks, all of those pieces, all of those elements that we have seen in the MDHHS orders, or even in orders that have come out from our local health departments. And how have they done that? Well, here in Michigan, there are two main statutes that you'd want to look at if you're going to follow along with the Michigan Legislature's website. That would be MCL 333. I probably have it up here. I do. 2253. That is the one that gives MDHHS, the statewide organization, to be able to issue certain kinds of orders. And the local one is MCL 333.2453. They have virtually identical language, except for one talks about it from the statewide perspective, whereas the other one talks about it from more of a local perspective. So with that being said, I want to talk about then specifically the kinds of questions I've had when it comes to these types of issues that are being required of people. I had a person call me, it might be almost a month ago now, that I know very well. I serve in one capacity or another with him in some roles that I function in, but he called me wondering about how is it that his employer could let him go for refusing to get the vaccine, or in some instances, people are refusing to just disclose their medical information. Let's say, for example, you work at a machine shop, or you work in sales or something of that nature. You know, not even anything to do with those straw man arguments that people try to bring up about, say, people that work in healthcare, or particularly with vulnerable individuals whose immune systems are compromised, and that's the entirety of the core group of people that they serve. Not even talking about that. That's, you know, can get into a whole different level of information and debate. But what I'm talking about is simple and straightforward and deals with 98% of our workforce in dealing with, you know, the requirements to not only get a vaccine, an experimental vaccine, but to be forced to get that before it's even in any kind of legit full approval stages by the FDA or the CDC, and then to disclose the personal medical information of individuals to their employers. Those are some significant issues. And people talk about HIPAA. The one thing I'm going to tell you right now is virtually every time somebody has referenced HIPAA and how it protects us, and you can't do that because you're violating HIPAA, virtually every time it's not been relevant. HIPAA deals primarily with the inability of our medical providers to be the ones sharing information with others. HIPAA does not prevent you from sharing your own information with your employer. So general privacy concerns and some, you know, at times from one state to another might have some statutes on the books that talk about you can't ask for certain information in certain contexts. You cannot ask someone's age. In certain contexts, you cannot ask you know, really a variety of personal information about somebody, such as, you know, when you're trying to hire them. But really what we're talking about, I just want you guys to know, don't reference HIPAA unless it's a medical provider who is the one directly conveying your personal health information to someone else. Again, for those that work in the medical industry, things get a little bit more wonky. So I'm not going to go into the specifics at this time about that. But with that context in mind, we're also talking about, of course, it could be the same issue with, you know, stores, for example, that are not allowing individuals in without wearing a mask or having their temperature checked, or, you know, having the COVID vaccine. So we're also dealing with that. School districts not allowing children to either attend school or play sports unless they get the vaccine, and they're wearing masks and they're using social distancing. Those are all the types of things that, again, I said originally 50 to 75%, probably 95% of you have asked this question to me already, or you have this question, one of these questions, and you're needing answers, and maybe just needing a refresher on some answers you've already received, because at times this information can be overwhelming. I mean, shoot, look how many colors I have up here. I have that many colors for a reason, to keep the information separate and distinct when I'm explaining it to you. So the, let's see, the first thing I wanted to point out is kind of jumping around a little bit. Let me see. I might wait a minute, actually. Yeah, I'm going to wait on that. I'll come back to it. It actually kind of ties in with the other board anyway. So let's look at what the statutes actually do. Again, that's MCL 333.2253 and MCL 333.2453. They're the ones that give the State Department of Health and Human Services and the local health departments the authority to issue orders when it comes to medical, public health epidemics and the like. So what does it allow them to do? First of all, for those of you who listen to me talk about the statutes and you're like, yeah, that's good enough. No, I want you to read these because they're not very long. The entirety of 2253 is all of 4 sentences. You guys got this. If you can read this statute. The entirety of 2453 I believe has the same 1, 2, 3, maybe only three sentences. Not that bad to take a read. So please do try to follow along with us here. The language is if the director determines that the control of an epidemic is necessary to protect the public health, the director by emergency order may prohibit the gathering of people for any purpose and may establish procedures to be followed during the epidemic to ensure continuation of essential public health services and enforcement of health laws. Emergency procedures shall not be limited to this code. And then the last two sentences there are actually talking about involving some other agencies in terms of sharing information and whatnot. It's not really relevant to their ability to mandate us or not mandate us to do something. So, and 2453 has the same information, only it talks about it in the terms of a local health officer. If a local health officer determines that control of an epidemic is necessary for the public health, and then it goes from there. So, all right, let's look at what that does, right? So essentially, it's really only 2 sentences that are at play here. 2 sentences. Even if you've never read a law in your life, that can't feel that overwhelming. They're fairly short, 2 sentences. Go ahead and read them. They're the ones I just read to you. But the first thing that the statute tries to do is give the health department the right to prohibit the gathering of people for any purpose. Number 1. We're going to come back to that. Number 2, to ensure continuation of essential public health services. And number 3, the enforcement of public health laws. So let's break that down a minute. Number 1, prohibit the gathering of people for any purpose. Please tell me that you guys at this point have heard me talk enough about the U.S. and Michigan constitutions that you know that's not okay. No statute can give any governmental agency or official the authority to prohibit the gathering of people for any purpose. That is the dumbest thing our legislature could have done. They don't have the authority to do that. The legislature does not have the authority to prohibit the gathering of people for any purpose. Therefore, they don't have the authority to give it to somebody else. No government agency can prohibit the gathering of people for any purpose. None, not a one. In fact, our U.S. and Michigan constitutions are pretty clear on this point. We have our first, the First Amendment to the U.S. Constitution, and we have, in here somewhere. Where did we go? Well, I was doing this all off memory before, but now I got to really think about it. We have the same provisions in our state constitution that give us protection for the freedoms that God gave us. God gave us the freedom to peaceably assemble, to speak publicly, to petition our government for a redress of grievances. And all of those functions, what it boils down to is those are guaranteed by the Constitution. specifically, if you look at the wording of the Constitution, those are supposed to be exercised unabridged. And I'm going to just scroll down here for a second. Undiminished, unrestrained, and unabridged. And if you want to follow along as to where I'm getting that wording, you can go to our state constitution preamble as well as Article 1, Section 5 of our state constitution. Again, let me reiterate that. We are to enjoy these rights that I'm talking about, including the right to petition, the right to peaceably assemble, the right to free speech, the right to consult for the common good, to instruct our representatives. And then in our state constitution, we have additional specific rights to recall officers, initiate legislation, and amend the state constitution. All of those and more are rights that are guaranteed to us by the Constitution, given to us by God, to exercise undiminished, unrestrained, and unabridged. Again, State Constitution Preamble and Article 1, Section 5 will tell you this. So, what has the Supreme Court said about this? Well, our Supreme Court, the U.S. and Michigan Supreme Courts, have very clearly said that someone's right to petition, assemble, or speak does not automatically end where a government official has determined that another person's right to be afraid and to want to require other people to get a vaccination or wear masks or be socially distanced, that one person's right to exercise all of their freedoms does not end where another person's rights begin. And certainly, the right to be afraid is not an enumerated right in our Constitution. The right to use your fear to require other people to do or not do something is not something that's protected within the Constitution. When I have the right to own my own home and be in my own home, if somebody else has a right to free speech and they want to come into my home and have a public speaking event without my permission, well, their right to free speech does not mean that they can do that on my home, in my home, on my own property. Those two rights obviously do not coincide, and that would not be something that would be acceptable. We all understand this, right? Well, let's think about it in terms of a parade or being outside of a voting precinct on election day. Let's look at something like that, okay? So you might think, how are these at all related? We were just talking about speech, and now we're talking about parades, and we were talking about vaccines, all related. So whether it's talking about being able to be present at a place open to the general public and being denied that because you can't or won't wear a mask, because you can't or won't get the vaccine or just don't want to disclose your private medical information, because you don't want to have your temperature checked, because you don't want to participate in contact tracing. Those are all relevant concerns that really can be handled and treated the same way, whether we're talking about an employer, whether we're talking about a customer. In general, if there is property open to the general public, it doesn't matter if it's the government that owns it or if it's a private organization like Menards or Costco. If it's a private organization or a public entity that owns property, but that property is open to the general public. Now, I'm not talking about the inner offices of a police station, right? That's publicly owned, but those are not open to the general public. I'm not talking about the back offices of your township clerk or your post office. That's not what I'm talking about. Those areas are not open to the general public, but the the foyer or the open areas, the outside, the sidewalk, the parking lots, the grassy areas around those buildings, those are open to the general public. When it's a store, again, it could be a grocery store, it could be Costco or Sam's Club or Menards or Walmart or, you know, any number of places. When it's open to the general public, that means the Constitution requires our government to protect us equally, to be able to ensure that we have equal access and equal treatment when we're on those facilities. So for those organizations or individuals that have been running around spouting out bad advice and horribly incorrect interpretations of the Constitution, there's nothing in the Constitution that allows you to open your facility, your place of business, anything. Now, if I had my home open to the general public for some reason, let's say I had a pool. I don't, that's why I'm dying right now. But let's say I had a pool and I wanted to open my home to the general public, and I had a sign out at the yard, and, you know, at the end of my yard, and I said, hey, everybody come swim for free at my house. If it was open to the general public and somebody wanted to come in and they wanted to, you know, I wanted them to wear a mask and they didn't want to, or I wanted them to have a vaccine and they didn't want to. I wanted to track them, you know, through contact tracing. If it's open to the general public, I cannot exclude those particular individuals unless the person is legitimately interrupting the normal course of operations, or unless the person is directly impairing the exercising of somebody else's rights. So for example, at the polls on election day, we have a state law that says you have to be 100 feet away from the door of the entrance to the polling precinct. If you want to, you know, wear shirts and hats that say, you know, Trump 2020, or if you want, you know, to get people to sign a petition or advocate in any way for a ballot proposal, our state law, and the U.S. Supreme Court has backed this up, says that you have to back up 100 feet or more from the front door or from any regularly accessible door to the polling precinct. Why? Think about it this way. In the course of normal operations, if people are like, let's say it's a petition signing, and you have your table and your chairs and your petition boards and your whole group of petition collecting individuals, they're all just right there, right in front of the door, and people cannot readily access. There's no ingress and egress to the building. They can't get in to vote. You are directly impeding the normal operations of that facility. So that's not permissible. And then look at it from the viewpoint of the voter. In that instance, you are getting in the way of a voter getting physically to the polling precinct and being able to place their vote and then leave, to have unobstructed ingress and egress from that polling precinct so they can exercise their right to vote and participate in our Republican form of government. If you are beyond that 100 feet, though, you're not impeding the normal operations of the facility, and you are not encroaching upon or infringing upon the rights of the individuals there to vote or use the facilities in some other normal way. You're not infringing upon their rights at all by doing that. Okay. So again, whether this is in terms of, you know, speaking or getting petition signatures, whether it's about just literally going in to buy groceries. Again, I know we're talking about a lot of topics, but the underlying rule is the same. They cannot require these things of you and discriminate against you based on these things, because that violates the Equal Protection Clause. The Equal Protection Clause says that the government's job is to step in and ensure equal protection of the law. It doesn't directly tell individuals that they can't run their businesses or open up their homes even in a way that is discriminatory. But what it does say is, hey, government, it's your job to ensure that there's no discrimination that's going to make it where an individual is found lacking of the protections that you could provide as a government. Because the whole purpose of government is to ensure that our rights are being safeguarded, and that when I exercise my rights, I'm not infringing upon you exercising your rights. That's the whole purpose of government. If government is doing something other than that, they're not doing their dang job, and they need to be stopped. And I don't care what level of government or what branch of government. That's it. That's the main picture. Their job is to ensure our rights. So not to give us our rights. So I mentioned in one of my earlier videos that because we the people have sovereign authority here, and the Supreme Court has said this as early as 1954, that the Due Process Clause protects our right to engage in a full range of conduct that an individual should be free to pursue. So again, goes back to your fear of what my actions might do does not justify trampling all over my freedoms. If me exercising my freedoms is not directly impairing your exercise of freedoms, then you need to leave me alone and I need to leave you alone, and we're going to each exercise our freedom. So I want us to keep that in mind. So again, we also kind of talked about the First Amendment in an earlier video, that the First Amendment protects, again, this is a quote right from our Michigan Supreme Court in a case from 1984. The First Amendment is what protects the right of access to places traditionally open to the public. If you have any kind of store or facility or government building, anything that's traditionally open to the public, the Due Process Clause protects the right of access. So no more can you say, well, I'm just following orders, or that's our company policy, or there's a local mandate, or there's a statewide mandate. No, doesn't fly. And for all property open to the general public, all members of the public have an equal right of access. Our U.S. Supreme Court clarified that in 1968 in the Logan Valley Plaza case. Let me reiterate. For property open to the public, all property, it doesn't matter if it's owned by a public person or an individual or private entity or a public entity, it doesn't matter. Government owned, private owned, all property open to the general public. All members of the public have an equal right of access. So it's important for us to recognize that as long as we're not intruding upon the normal operations of a particular facility, then you have a right to be there. And if you're not directly impairing the right of anybody else to exercise their own rights, then again, that's not disorderly conduct. So let's also think about this in the context of things. The very idea of a government, Republican in form, keep in mind, Article 4, Section 4 of our U.S. Constitution guarantees us that Republican form of government, and Article 1, Section 1 of our state constitution here in Michigan says that all political power is inherent in the people. So keeping those two provisions in mind, the very idea of government, Republican in form, implies a right on the part of the citizens to meet peaceably for consultation in respect to public affairs and to petition for a redress of grievances. And that is from our U.S. Supreme Court in 1939, not a new concept. They actually were citing a U.S. Supreme Court case from 1876. 1876. And you can also look at our state constitution, Article 1, Section 3. So assembly, discussing public questions, those kinds of things are traditional uses of public places, like libraries, parks, streets, facilities where government bodies meet, but also, depending on the type of private entity, it might even be a traditional use of those facilities. It doesn't mean that that was the primary purpose of that facility, like a library. The primary purpose, you would think, has something to more do with checking out books. But if it's a traditional use that has been recognized by our society of that type of facility as a gathering place, like a coffee shop, for example, then the people, the members of the general public, have a right to be able to utilize that space and exercise those freedoms equally. And it's the government's job to ensure that those rights are protected equally. So back to a little bit more specific with the medical side of things and MDHHS mandates. The First Amendment does not guarantee access to property simply because it might be owned or controlled by the government, or because it's a private parcel that is restricted or given licensing or things of that nature. But the First Amendment does protect a right of access to places traditionally open to the public. And we already talked about the Due Process Clause and the Equal Protection Clause. So something else to talk about is, even with private property, our U.S. Supreme Court, in that Logan Valley case I talked about from 1968 in the U.S. Supreme Court, even with private property, this is a quote, ownership does not always mean absolute dominion. Not the dominion we know of these days. But the more an owner, for his advantage, opens up the property for use by the public in general, the more do his rights become circumscribed by the statutory and constitutional rights of those who use it. And it may be treated as though it were publicly held. So again, 2 points there. One is when you have, let's say, I'll just pick on Costco again. You have a Costco facility and it's open to the general public, and people can come in and, purchase a one-year membership, and they can buy milk and buy tires and clothing and whatever else, right? So that facility, the owner, the people that benefit from the sales of Costco, let's just pretend it's one guy who owns it and keep it simple for now. Mr. Costco would then benefit financially from the facilities being open to the general public. The more people that walk through the doors and buy things, the more it lines his pockets with cash, right? So the more that somebody who owns property opens up their property to the public, and they're getting some sort of benefit out of it, they're getting payment or they're getting whatever. Typically it's money, but it can be in other ways. Then that property can actually be treated as though it were public property owned by the people. Okay. So that is a concept, again, recognized for quite some time and clarified by the Supreme Court in that way, at least as early as 1968 by the U.S. Supreme Court. So where does that leave us? Well, another piece to that is, let's look at it this way, because, you might encounter people that say, other constitutional attorneys that are arguing the other side. Well, if you're a private business owner, then you have the right to keep everybody out that you want. That's not true, but here, let's give you some other pieces to be able to combat that misinformation. For all property open to the public, and this is another direct quote from the Logan Valley case from the U.S. Supreme Court in 1968, for all property open to the public, quote, no meaningful claim to protection of a right to privacy can be made. Okay, so think about it that way. I talked about my home earlier. If using it as a general home, even though my work is out of my home is my home. It is not open to the general public. And it is, I have a right to privacy in my own home. I have a right to run around in my bathing suit if I want, or my husband and I can play what kind of music we want, or whatever boring board games that people might otherwise think we shouldn't be doing. Who knows, right? We're not big drinkers, but if we were, we'd have the right to drink here. It's our own home. So you have that right to privacy, and that right to privacy comes up in a lot of contexts. It's been misapplied to certain situations, such as in the abortion context, but it's also very clearly been talked about in terms of like the Fourth Amendment, and when the government is trying to pursue criminal charges against you. There's a wide variety of situations where it comes up, but overall, we each have a right to privacy. That's where, when your employer tries to get you to disclose your health information, provide verification, such as another friend of mine shared with me this week, they wanted verification of their medical history that they have in fact received the COVID-19 experimental vaccine, labeled experimental. This, again, for those of you who might still be skeptical about what I'm saying in that regard, I'm going to point to one guy, even though he's definitely not the only one, just off the top of my head. Dr. Martin Dubrovic out of Cadillac, Michigan, is an expert immunologist and epidemiologist who does roughly weekly newsletters, a little bit better than I send mine out sometimes. What he has been doing is been trying to combat the misinformation that's out there, and he leads you to a link with a source directly from the CDC, or I think he's referenced the World Health Organization. In any event, he's not just making this stuff up. It's not coming from his own patient files even. It's coming from the very sources that are turning around and telling you, oh, you need to get this vaccine. It is experimental, and the results are, according to him, an expert immunologist and epidemiologist, the results are of the adverse effects and reactions, even death, are being so underreported that it really undermines the credibility, whatever the CDC had left of credibility, as well as the credibility of the particular drugs that are being administered to people in this trial basis, approved on this not full approval status from FDA and recommended by the CDC. So I want you to keep all these points in mind. So, and I already covered that because I'm ahead of myself. So I want to round out again. People cannot be excluded, whether they're there to peaceably assemble or just to exercise free speech in some manner, just by wearing shirts or just by being present without a mask on or whatever the situation is. They cannot be trespassed, right? It's not trespassing, whether it's publicly owned or privately owned, it doesn't matter. If they are on property open to the general public and they are not obstructing normal operations and they are not interfering with the rights of others to their normal use of the property, then they can't be kicked off the property for any reason. But certainly, if you are on public property, scratch that. If you are on property open to the public, doesn't matter who owns it, you cannot be charged with trespassing. Okay, well, they can technically do something that they don't have the authority to do. We've seen that in my case. And I'm going to talk about more of that in a minute. But let me get back to the other two elements here of this statute. MCL 333.2253 and MCL 333.2453 are the two statutes we're talking about, especially if you're just kind of joining us here. These public health codes provisions, the second point is that those orders can be used to, quote, ensure the continuation of essential public health services. So let's break that down. ensure continuation. Well, anything that wasn't happening or being offered or being done before the epidemic, as it's referred to in these statutes, nothing that was done that wasn't being done before COVID would be continuing, right? It's literally a continuation of something that had already been started. We were not doing contact tracing. We were not doing microchipping. We were not requiring the COVID vaccine. We were not requiring masks or social distancing or temperature checks. So none of those could be the subject of any of these orders, just based on the first couple of words right there. But then let's continue. Of essential public health services, essential, is forcing someone to get the vaccine that is experimental and not even proven to work and is not even designed to truly function as a vaccine, but rather as a typical booster, like the flu shot, that is only has efficacy from 40 to 60% of the people who receive it for various reasons. That's not a true vaccine. That's not going to wipe out the disease, the illness, whatever we're calling it. That's not going to wipe it out just by getting the shot with the COVID vaccine or the flu vaccine. So it's not essential, because getting it doesn't even solve the problem. What about the masks? Well, let's think about some of the things that people that are expert, PPE experts, such as Kristen Megan and many others, have talked about how you utilize the masks. And look at society as a whole. Does society as a whole really read that whole box of directions? Do they really follow in detail every step of what is appropriate? No, especially when we're talking about children or teenagers. I've got some of those, let me tell you, or husbands. They're not necessarily going to follow every single step to that. Well, if you want to use PPE, if you want to have masks or any of the other PPE, it's only effective if you're using it the right way and if you're using the right materials. There's been times where both the CDC and MDHHS and the World Health Organization and even Fauci, all of them have said, well, you can't use those drugstore masks. They're not going to do any good. You can't use those homemade cloth masks because they're not going to do any good. You know, the cloth has, or even the like the dust masks, the fibers on them are too loosely woven, essentially, and those microscopic particles that are where COVID-19 lives, those particles are so minute, more so than so many other infectious disease materials and cells, that they, I think Kristen Megan Kelly once had a Facebook post that was a little meme, and it showed a chain link fence and was talking about, maybe it wasn't her, maybe it was somebody else, but it's wearing a mask, especially one of those kinds of masks, to stop COVID-19 is like putting up a chain link fence and expecting the mosquitoes to stay away. A mosquito's going to come right through that thing. And most of the masks that we see all around in the public are the same way. They're not actually going to stop or even slow the spread. Yeah, you might think you're stopping or slowing it because as we talk and speak and sing and whatever, you know, we have the moisture, or, you know, if we spit or sneeze or whatever, all of those droplets, right, are being slowed by wearing a mask. But it's not, that doesn't stop the COVID spores. The COVID spores themselves continue right on through those masks. And now, if you actually have looked at the last several of the mask orders as required by the MDHHS, they've actually gotten very specific. They're saying face shields don't count. You can't do that. You have to have a mask. Oh, and it can't be made of any kind of plastic or metal or, you know, any kind of silicone or anything like that. They say it has to be a fabric mask, essentially a cotton mask. And neck gaiters don't count. It has to be tightly fitted to your face to cover your nose and mouth where you breathe. And it has to be a cloth material. Let's think about that. Cloth, chain link fence, mosquito. The idiocracy, when we've come full circle, my point, I won't go down too much more the medical or scientific side because that's not what I'm here to do. But my point is, it's at least widely enough debated on the efficacy of using those kinds of things that they're certainly not essential public health services. But let's look at the last word there, services. So the government, according to these statutes, can make these orders to ensure the continuation of essential public health services. So the government wants to ensure, say, that they can do possibly mammogram screenings, pregnancy tests, prenatal care, well child checkups, cancer treatments, right? Anything that is an essential service provided to the public, maybe education. Maybe there's education needed on, years ago when I was in school, I'll just say that, we had like an awakening of public health information in terms of, those public ad campaigns about how to eat right. And they really hammered on the food pyramid back then, which they have now changed. But, that you're supposed to get so many grains and so much of milk and fruit and vegetables and all this stuff, right? Proteins, that educating people about what kinds of foods and vitamins might be needed during pregnancy or at older stages of our life or whatever, all of those things, providing information, providing services or screenings, those are, you could argue that those are essential public health services. But the bottom line is a service is a service. If somebody comes here, it's the same kind of service. Don't think it's magical and special just because it's in the law, that it somehow is some sort of legal term. No. The term was made by everyday average people, supposed to be everyday average people who are your legislators, and they represent the everyday average person. And these are statutes meant to regulate the everyday average person. They have words that mean the everyday average meaning. So if a lawn company pulls up right here and they hop out and they want to start, they offer a service, a lawn mowing service. And you know what? I'm going to pick on my friend Micah. He might be watching. I don't know. So let's say my friend Micah decides he's going to drive all the way over to Hudsonville and he's going to bring all this lawn equipment and he wants to mow our lawn and offer us that service. And then I don't know what his rate is. Let's say it's $25 each week. I have no idea. So let's say though, I just cut a deal with my neighborhood because our older teenagers are done with high school and all that. So Emma's a little too young to be driving the riding mower by herself. But anyway, let's say I cut a deal with my neighbor kid and he mows it for $10 or $15. Well, I'm going to say, you know what, Micah, I love you, but maybe not. I don't think I want to utilize that service right now. I can get a better deal with this kid down the street. He can earn some money. Oh, wow. He can earn some money. It's a win-win for those of us here. So Mike would have to say, well, that sucks. I just drove all the way here thinking I get to mow your lawn and earn some money. But okay, it's a service. You have the right to say, no, thank you. Same thing here, service. So like I said, cancer screenings, mammograms, prenatal checkups, education on what to eat or drink or what to avoid during pregnancy, or maybe when you have cancer, are there, is there a certain kind of information that can be provided to people suffering through something like that, of ways to improve their chances of having, less complications. Those would be services, right? Services that you can choose to take or leave. If you have cancer, The government can't say, oh, well, it's an essential public health service that you go through chemo. We are going to require you to go through chemo. No, even if they say it's now an epidemic because more and more people are getting cancer, which they are, of all different kinds. The government still doesn't have the right to say, well, we're going to mandate you to have chemo because it's a service and it can help your health. So anyway, that's point number 2. Point number 3, they can supposedly issue these orders to enforce health laws. Let's think about that. They can issue an order to enforce health laws. Pretty much that's the most useless thing up there because they can't require you to do anything new that's not already required of you in a statute or in the Constitution. So it just says they're going to do their job to make sure that we're following the law. So, what is a law anyway? I can't remember his name right now, but one of my own county commissioners here in Ottawa County, man, I think 10 of those guys, at least, if not 11, need to be replaced. What is a law? Is a government mandate a law? Maybe. Is a health order, a public health code order that comes from MDHHS or the local health department through one of these 2 statutes, those orders and what they require, are those mandates? Are they laws? No, not even by any stretch of the imagination. If you want to know in Michigan what a law is, go to MCL 8.8. There's only 3 ways something can be a law. Number 1, if we initiate it as the people, right? So you had the Unlock Michigan petition last year that the people of Michigan gathered, whatever it was. I think in the end they ended up saying there was over 400,000 valid signatures. And then it went to, well, they held it up and it didn't go. But let's say they turned in the signatures and right away it was turned over to the legislature, or it can go to the ballot. In any event, if it's people-initiated legislation, our state constitution allows for that. So the people can make laws. And yes, it takes a law to repeal a law. So there could be a law that says this law is now repealed, such as these should be. These should be repealed completely, gone. In fact, Unlock Michigan has announced that they have a new petition. I'll get into that in a minute. But those are in public, people-initiated legislation. You have the typical way of making a law, right? Where you have one house of the legislature that passes a law, and then another house that also passes the same language, and then it goes to the governor, and the governor either signs it and immediately it does become law, or it might become effective later, but it's immediately a law, or if the governor decides to veto it, then it goes back to the legislature. And if they have a 2/3 vote, then it becomes law anyway. Third way you can have a law is in Michigan. Article 5, Section 2 of our state constitution allows the governor to issue executive orders that reorganize the executive branch. Instead of these departments I want to combine or merge or have these people or this head of a department does this function, those types of things can be done by an executive order, an EO, as we all now know them, as referenced in abbreviated form. And those cannot be used to regulate the people. Those can simply be used to reorganize her own branch or his own branch of government. And they have to be presented to the legislature, though. I believe it's 60 days, and the legislature has to speak up if they want, in a timely fashion, if they don't want to allow that change to go through. That would be considered a law if the legislature decides not to challenge that. And it's only reorganizing the executive branch. Only 3 ways that you can have a law in Michigan. Okay, MCL 8.8. So all of those ways, no matter if we're talking about this piece or whether we're talking about this piece or any one of these, there's so many words that even the individual word alone, let alone if you look at the whole thing, what it says is the government cannot really do what the statute says that it can do because the Constitution is the supreme law of the land in all times and in all places, no matter what. There's a post I made about that had the exact language from a recent court case. No times of epidemic or pandemic or any kind of other crisis just give excuse to violating the Constitution. None. If it's not in the Constitution, my husband kind of was trying to make an analogy about monopoly, right? The rules of monopoly. You can't just violate the rules of monopoly unless the rules of monopoly say you can violate the rules of monopoly, right? But there is no part of the Constitution that says you have to follow the Constitution unless something is scary or we have drought or pandemic or whatever. There is no part to the Constitution that says that. In fact, our state constitution might be on here somewhere. Article 4, Section 52 of our state constitution even says that our state legislature can only make public health laws that are suitable. If it's not constitutional, it's not suitable. That's an obvious one. So, mask requirements, are they legal? No, they're not even following their own stinking thing here. A mask does not fall into any of these provisions here. Are they constitutional? No, absolutely not. No matter what they do to this statute, allowing the health department to issue orders to control the people and issue mandates and require this and require that of the people in ways that clearly violate the state and federal constitutional provisions that protect our God-given liberties, it's not going to be constitutional. So, what does this mean for, and we still have a separation of powers issue too, right? Because think about it this way. By making these orders, we have people that are being told, well, at this particular time, because these orders are changing every 5 minutes, I even stopped keeping up with every single one because I had been reading every single one of them word for word and cross-referencing with all the prior versions to see what has changed and what has remained the same. Who cares? They're unconstitutional. And it's for the same premise, the exact same premise that the Supreme Court said in October after myself and a couple of other attorneys were arguing against these orders last fall. And that is that these orders, whether it's the governor or whether it's MDHHS, they're part of the executive branch. And so when they issue an order that is impacting every area of our lives, and they are saying not only that, but then they're saying if you violate any part of this order, then you're committing a crime. They are legislating, they are creating laws. You can't have the legislature giving the executive branch power to create laws by simply calling it something else like an emergency order or an executive order. I don't care what you call it. If it's not legit, it's not legit, and it's not. So, and some things to keep in mind, right? Article 1 of our U.S. Constitution does the same thing that Article 4, Section 1 of our Michigan Constitution does. It describes where the legislative power resides. It's the legislature. Article 2 of the U.S. Constitution and Article 5, Section 1 of the Michigan Constitution, executive branch powers. Article 3 of our U.S. Constitution and Article 6, Section 1 of our Michigan Constitution, judicial powers. Those are important. And they're really not long provisions. The Michigan ones are even shorter. If you haven't read them yet, I'm going to ask you to do that. And there's that Article 5, Section 2 of the Michigan state constitution that I mentioned earlier. And let's not forget this, as far as separation of powers, this is a 3, not a 5. I realize from the video it might not look so clear, but Article 3, Section 2 of our state constitution very clearly says that no official exercising one power of, let's say, the executive branch can exercise any powers of another branch of government, say the legislative branch. If you are serving in the executive capacity, you cannot exercise judicial or legislative powers. That's just how it goes. Because the more you funnel all those powers into one entity or one individual, then what? Tyranny is sure to come. So also, we want to keep in mind a few things, right? Article 6 of our U.S. Constitution, Article 11, Section 1 of our state constitution, state law, MCL 15.151, they all require that every single public official, every single public employee, everybody serving in government has to uphold the U.S. and Michigan constitutions, period. That's it. They don't take an oath to protect the public from a pandemic. They don't take an oath to protect us from any other scary thing, from a drought or from disease or anything like that. They take an oath to uphold and support the U.S. and Michigan constitutions, which, again, the purpose of those were created, and what they actually do is to ensure that we have the ability to exercise our God-given liberties, including Article 1, Section 23 of our state constitution and the 9th Amendment to our U.S. Constitution, which are our unenumerated rights. We don't have to prove that we have the right to breathe fresh air. We don't have to prove that we have a right to not get an experimental injection. We don't have to prove that we are free from contact tracing or microchipping or social distancing or temperature checks. We don't have to prove that. We are given God-given liberty and freedom from our Creator, and it's our government's job and oath to protect that liberty, even if it's not spelled out specifically, as long as our exercise of our liberties does not directly infringe or impact the exercise of somebody else's liberties. That is the job of government. So let's round this out, because it is with a heavy heart that I'm going to give you my take on the new petition that has come out. If anybody's even still watching, I know we have several. So, health. How many times is the word health used in the U.S. Constitution? Since you're the only live audience member in the room, how many times is the word health used in the U.S. Constitution, Michael?
It's either 0 or 1.
You get to cheat because it's right on the board.
It's 0.
0! 0 times. Well, you're here with me live too, but nobody was answering. I was looking. Oh, there we go. I got a whole bunch of Zippo 0. Okay, now everybody's answering. All right. 0. How can public health be something that the government has authority to mandate, control, do anything with, when the word health isn't even in the stinking Constitution? Let's think about this. It's common sense. The Michigan Constitution, it is in there 4 times, but in 3 different contexts. Natural resources. COVID has nothing to do with natural resources, right? Pollution of public streams and lakes and things like that. Okay, that's a different story, but it has nothing to do with COVID. Owning property. Well, if we need to have a municipal hospital or something of that nature, then the state or city or township or whatever can own a hospital to serve the public health. And again, Article 4, Section 52 of our state constitution says that we have to make laws that are suitable for the public health. It's not suitable to make a public health law that is not constitutional. welfare. A lot of that's that second term that people use in terms of making all these mandates and restrictions and requirements. It's for the public welfare, the greater good. The U.S. Constitution only uses that word twice. One is to promote the public welfare. When you're promoting something, that's like if you are promoting your newest invention, or you want to sell Restore Freedom t-shirts, and you are so excited that you have these really awesome purple and black Restore Freedom t-shirts, and you want to promote them. So you do ads on Facebook, and you do ads on all kinds of social media, and you do email blasts, and you go to different events, and you have a table or a booth, and you're out there telling everybody, and you're posting business cards on displays at gas stations and restaurants, and you are telling everybody about these awesome Restore Freedom t-shirts. You are promoting the sale of those shirts. You're not forcing somebody to buy them. You can promote them, but if all people or any person decides, you know what, dude, I don't have money, or I don't wear t-shirts, or I don't like Restore Freedom, I like tyranny, whatever. You can't force something on somebody in that context. It is to promote. The word means the same thing here. It's to promote the general welfare. The government is supposed to promote the general welfare and pay for. That's the other context it's talked about. If you look at that provision of the U.S. Constitution where it mentions the word welfare, it's talking about providing for. Like when you go out and you earn a living and you are providing, let's say, let's keep it simple. Let's say Mike and I are married and have no kids, which we do, but let's say we don't for a minute. So we're married, we have no kids, and we've decided that I'm going to stay home and fight for freedom, and he's going to make all the money and pay for my student loans and stuff like that, right? That'd be nice. Anyway, he would be out to provide for the general welfare of our family. He would be providing for us to pay for our bills and be able to have food to eat and a shelter and things like that. Is to provide for, to pay for the necessities that we need, not to require me to do something or not do something. In fact, even though at this point, especially for the last year and a half, when I've been working for free for the people of the state of Michigan and for the U.S., and not been bringing in paid case income, he's been bringing in whatever money we have, besides people like you that might be willing to donate to us on restorefreedomkh.com, by the way. But anyway, let's say as the primary breadwinner of our family, Mike said that he wanted me to start wearing masks in public. Hey, Mike, come here for a second. He had no idea that when he came home that he walked in this room that I'd be putting him on the spot. But you should have guessed. Oh, resistance to tyranny is obedience to God. What a great shirt. I didn't even dress him this morning. Can you get a little closer so they can see you? Okay, back up a little bit. Yeah, okay. So, Mike, pretend for a minute that you want to tell me, as the primary provider, breadwinner of our home, that you want me to start wearing masks when we go in public. Go ahead, try.
That's pretty hard to say.
Just try.
Especially in front of you. As the primary breadwinner of the family, I think we should start wearing masks.
No, you're trying to mandate me to wear a mask, like the government's trying to do. Okay.
Well, that's even harder.
Yeah, I know.
Yeah.
Just pretend.
We will start wearing masks.
He's trying to tell me what to do.
That is funny.
Yeah, it is funny. So do you think that would be my normal reaction if you tried to tell me what to do?
No.
Would I say, yes, sir?
Over my dead body.
Okay, that'd be more likely.
Yes,
How successful is it to, because you're the primary provider of my general welfare by paying for, despite donations, or in addition to donations, you're the primary person that's providing for my food or my clothing or my shelter right now. How well does it work if you try to tell me what to do and mandate I do something?
That is not successful. No, that doesn't work.
No, doesn't work. Nor should it. Thank you.
You're welcome.
Nor should it. So that's literally what that second provision in the U.S. Constitution talks about. The general welfare, to provide for the common defense and general welfare. So my husband is supposed to be in our family home. He is supposed to be the one, just like the government in the terms of the Constitution, in our family, my husband's supposed to be the one to provide for the common defense and general welfare. He has more knowledge of the firearms that we have. He has more knowledge about knives or explosive materials or whatever, right? He has the way to defend, to provide for the common defense of our home and of our family and of me. And that's very analogous to what the government's job is supposed to be. To provide for the common defense and general welfare is exactly of how, our government is supposed to be trained in firearms and explosives and in all of those kinds of defensive tactics, because if we have, say, a September 11th, 2001 situation, our military needs to hopefully catch it before it happens. But if they don't, they need to be able to know how to address that issue head on and defend us. And to provide for our general welfare, to be able to pay for the essential services or offerings that are required in our Constitution. We need infrastructure to be able to have a country. We have a right in the Constitution, at least even as interpreted by the most liberal of judges, we have a right to move freely from one state to another, from one part of the country to another. Well, how can you do that if the infrastructure doesn't exist, right? We have a need for all kinds of other infrastructure and things that would be in the sense of providing for the general welfare. Our Michigan Constitution references that word 3 times. One in the sense of atomic energy, not relevant here in the slightest. One, again, in the context of natural resources, also not relevant here. And another is where we talked about over here with, I have it somewhere. I thought I did anyway. Article 4, section 50. Oh, I've been saying 52. It might be 51. Anyway, Article 4, section 51 or 52 of our state constitution. It's like 90 degrees in my office, so my brain is now turning into mush. Where the legislature, it says that the public health and welfare are important, but then it goes on to say that it's only suitable laws regarding public health that are allowed to be passed. So it references the public welfare, but then does not give a specific set of permissions or authority for the legislature to make laws regarding the general welfare, only recognizing the general welfare is important, but that it's the public health where laws may be made. Safety. Well, it's all about keeping us safe. Let's stay safe and stay healthy and whatever. We're all in this together. Whatever. I know my dear friend Rachel has had a bunch of drinking games about all the catchphrases, or at least thought it would be funny to do a bunch of drinking games on some of those catchphrases. So safety is another one, though, that has been used for decades as a way to give the government power to control us, right? Well, it's all about the public health, welfare, and safety. The U.S. Constitution mentions the word safety 1 time, and that's referencing if the public safety so requires, the writ of habeas corpus may be suspended. Habeas corpus has nothing to do with whether they're going to try to require us to wear masks. Michigan Constitution, that word safety is in there 6 times, but really only in 3 contexts that might be remotely, arguably relevant. 1 is actually habeas corpus, again. 2 is the natural resources provision that we talked about. And 3 is to own property. So in this case, it would be like if the sheriff's department or police department had a police station, or the sheriff's department had a building that housed the the sheriff's department and all of their personnel and their equipment. That gives them the ability to own property for the public safety. So all of this goes to one conclusion, right? If you look at the words of the current proposal by Unlock Michigan, the current proposal is to add that these mandates and doing this, they're not changing any of this language. They're still saying you can prohibit the gathering of people for any purpose. They're still saying that, well, even though the problem is that these orders have been used to violate what's even allowed, we're not going to address that issue at all. We're going to leave that language exactly as it is. And all we're going to do is make this statute exactly like the 1976 law that the governor already used to violate many of our freedoms. They're adding the language that the authority of the director to issue, revise, or enforce an emergency order under this section shall continue for up to 28 days. After 28 days, an emergency order is automatically rescinded and unenforceable unless a request by the director for an extension of time to issue, revise, or enforce an emergency order for a specific number of days is approved by resolution of both houses of the legislature. And they're proposing that language change in both of these statutes. So they're saying it's okay for the health department to require all of this stuff and do what they've been doing as long as it's only for 28 days. So according to the statutes we have on the books, the governor has her crack at 28 days with the 1976 Emergency Management Act. Then her employee, right, her Department of Health and Human Services director can then continue her dirty work through MCL 333.2253 to issue statewide orders for up to 28 days with this change, proposed change. And then if they were smart, then they would say, well, they're going to wait for the local health departments to issue their orders until these ones expire if the legislature doesn't extend them. So without any cooperation with any other level of government, without any cooperation with the legislature whatsoever, without any consent of the people, and without any care for what the Constitution requires, our government, through the 1976 law and then MCL 333.2253 and then 333.2453 can, through the governor, then MDHHS, then local health departments have, I can't even do the math on that. Mike, what is 3 times 28? 56 plus 28, but I can't do that beyond that right now because it's so hot in here. So you get my point. It's essentially 3 months. What? Should be 74, I think. We're going to go with that. 74 days. No?
What was the numbers?
28 times 3.
Oh.
74. Thank you. Somebody confirmed for me. Okay.
84.
What?
You said 28.
Yeah. Times 3?
Yeah.
It's 84?
Yes.
Oh, somebody else did say 84. Okay, well, at least I wasn't the only one that did the same math there. Anyway, 84 days. That means for 84 days, the government, just the executive branch, can control us and continue to require contact tracing, possibly microchipping in the future, COVID vaccines, flu vaccines, masks, social distancing, temperature checks. They can close down every business and every school. They can say, nope, you can't have capacity more than 2 people. Or they could just say, nope, you can't have any at all. They could say, oh, well, it's a Lowe's or a Home Depot, but you can't sell paint. It's a home improvement store, but you can't sell home improvement items, whatever, right? They could do all that crazy stuff that we've seen before, according to this new petition. This petition is saying, go ahead and do the exact same orders, but now we're going to say you have to stop at 28 days unless you have the legislature's permission. So again, The 1976 law is, which I forgot the cite to that. It's not the 10.31. It's, oh my gosh, I don't remember. Anyway, the other one, the 1976 Emergency Management Act, that one gives 28 days to the governor without any extensions from the legislature. Then state MDHHS can go do their 28 days. Then local health departments can do 28 days. And so you have 84 days where the executive branch can require us to do all of these things. What good is that kind of a petition? So, oh, well, somebody's saying I should turn on the air conditioning. Well, I actually would want to be in the sun. If I'm going to be sweating like this, I at least want to be in the sun because I'm solar powered. But at any rate, I could see the sunlight. It's kind of close. When I'm done here, I'm running out the door. But anyway, so I hope I made my point with that. And it's a bummer because I think the people, I don't know who wrote it, but I think that some of the people involved, if you saw my video, I made video number 2 today, you know that it's Stand Up Michigan. And although they haven't always been kind to me in public, I really believe that Tammy Clark and Jeff Simpson and certainly Kristen Megan and whoever else might be on their board or part of their organization, I really believe that they really do want to fight for freedom and at this point have been given bad advice. So it's a bummer. I guess I'll put it that way. It's a bummer because I would love to have something that could be a joint effort that we could join forces and like, can you imagine? Could you imagine if every single volunteer, that the thousands that we had with Restore Freedom last year and the thousands that they had with Stand Up Michigan last year, if all of those volunteers saw the organizations fighting for the exact same petition or whatever it is, if it was a petition, could you imagine how quick we could get whatever the requirement was for signatures? That would be record breaking. That would be phenomenal. That would be the kind of thing that we would inspire people all over the country to get off their tushes and stop expecting somebody else to fix their problems, to stop expecting some other freedom fighter, attorney, doctor, whoever, to do all the dirty work. That would inspire people to get up and say, it's we the people that need to take back our government, take back our country, and defend our freedom that God gave us. That's something I'm hoping will still happen someday. And I know that my publicly portraying my opinion of their petition is, going to cause some problems with that budding friendship that we have, but it's the truth. And so do I want you to write off Stand Up Michigan just because of that? If you have some sort of other issue with Stand Up or, whatever else is going on there, that's something distinct. But don't say that organization is, or the people in the organization are automatically worthless just because the petition is not going to help us. Don't do that. Definitely not on my account.
How should it be written? I mean, is it possible to rewrite it?
What the petition should do is, what they did with the 1945 law? If we're going to do it just law by law, then what they should do is a petition that repeals the 1976 Emergency Management Act, takes one sentence to do that, and repeals, I would repeal the whole public health code, but to repeal these two statutes here, 333.2253 and 333.2453, there is no good ever in any situation that comes of the government having the authority to prohibit the gathering of people for any purpose, period. And there's no reason to have a law that says you can enforce other laws. Why? So certainly the stuff in the middle, we're just ensuring public health services. That doesn't even need to be a statute. But if somebody was going to keep this part of the statute, They'd have to clarify for those in government that don't know how to read that a service is an optional thing that the people can determine for themselves if they want to utilize or not. So mandates are a no-go when it's a service. So to answer my husband's question, if I were writing that, or if I were looking for something to sign, I would love to see a petition that took a sentence to get rid of the 1976 law, just like they did with the 1945 law, to get rid of 333.2253, to get rid of 333.2453. Get rid of them. They are not needed at all. It's as simple as that. But my husband's got that look on his face, so yes, hon.
Well, my next question is how do we get it through the Board of Canvassers? Is 1945 repeal still awaiting a court hearing?
You didn't hear?
No, I haven't.
My husband was asking, how do we get a petition like that through the Board of State Canvassers? Because he did not hear the news that the Michigan Supreme Court said they had one job, and their job, essentially, given all the factors, was to send the language right on through. They ruled already. The Michigan Supreme Court ruled on that petition.
Oh, so that one.
It's a go.
Okay.
So
it's repealed now then?
Well, no, because it
How long
still
does
has
it
to, the Constitution requires the other steps, but that's not what this video. Do you have any more questions about this? Okay, he's giving me all kinds of weird faces now. Not sure what that's for, other than he's
I'm just making
strange.
faces at you.
Thank you. That helps the video. The heat's really going to his brain too, as you can see. So let's see. I'm going to leave you with one thing that we talked about at the beginning of this video. See, I told Lori I wouldn't be. She's doing something and I'm doing something. I said, let's race. And she's like, oh, you'll be done with your video first. And I was like, one of my videos being quick. Right. Okay, so when you're on any kind of property open to the general public, can you receive a lawfully issued trespass citation? Can you be arrested for trespassing? Well, the answer is no matter what state you're in, because the U.S. Supreme Court clarified that many years ago. But let's kind of peel apart Michigan's trespass law because it's super simple. In order to be guilty of criminal trespass here in Michigan, that's statute 750.552. I think you can see this. Maybe not. It's probably super tiny. You have to intentionally remain without lawful authority on the premises of another after being notified to depart by the owner or the occupant or the owner's agent. So they have the word occupant in there, like if it's an apartment building and you're renting an apartment, if you tell someone to leave, well, you have the right to tell somebody to leave if you live there. But it's a pretty simple statute when you really look at it. And the person that is on the property has to have lawful authority. If you have lawful authority to be, say, on property of a store that is open to the general public, you have lawful authority to be there because the Constitution, whether you look at the First Amendment or the Due Process Clause or the Equal Protection Clause or a variety of other things, you have a lawful right and a constitutionally protected right to be present where other members of the general public are allowed to be present. So you cannot be arrested or charged or cited for criminal trespass here in Michigan, according to the language there. Or, like I mentioned, you actually can't receive a criminal trespassing charge in any state of the U.S. for these same reasons. And the Supreme Court clarified that. So I realize if you've been listening from the beginning, I've probably had a few too many truth bombs or blown your mind a little bit, but you can replay this later. And keep in mind, even though we went through a lot, you have rights. You don't have to prove that God gave you rights, But the government does have to prove that they were given authority, lawful and constitutional authority, if they want to do anything. The government does not have any rights of their own unless the Constitution gives them that authority. So don't feel like you have to find the specific constitutional provision that allows you to breathe fresh air without a mask or not have an injection of an experimental drug just to maintain your employment. You have those rights that are given to you by God and guaranteed to be protected by Article 1, Section 23 of our state constitution, and the 9th Amendment to our U.S. Constitution. So with that being said, all right. So with that being said, I'm not sure if there are questions, because I have YouTube, I have Facebook, I have a couple different channels actually here. Let me see if there's anything. So a couple of things. Number one, somebody's asking me to write a brief that talks about all this. So I guess with the purpose of hoping that Stand Up Michigan or Unlock Michigan is going to reword their petition. My guess is that they don't really care what my position is on it, no matter what I say. And I don't have the time to do that. I at least owe it to you guys to give you the information that I know is there. Just like at the beginning of their petition, the first go round, when they wanted to get rid of the 1945 petition, the 1945 law. And I was telling people way back last April, May, June, July, you name it, getting rid of the 1945 law is not going to solve our problem. And unfortunately, a few thousand people, too many, did not heed my warning until the Supreme Court declared that law unconstitutional on October 2nd. And then the governor started using the public health code, which I have been warning people was a problem. Again, these are not our only problems. There are many statutes that are a problem, which is why I wrote the Restore Freedom Constitutional Amendment petition. And wouldn't that be something if Stand Up Michigan, Unlock Michigan, whatever, I don't care who, if they wanted to use all their resources, because they've got a lot more, they've had millions of dollars donated. Not so much. So if they could use those funds and those resources to be able to get something like even the Restore Freedom petition, if they wanted to take it and run with it and slap the Unlock Michigan or Stand Up Michigan name on it, that's fine with me. I would still be totally happy to argue in defense of that at any event or in any court, knowing what the certain individuals in government power right now would do to fight it. But I would definitely take on that task, no matter whose name is on it. That would be my hope. But at the very least, I'm hoping that enough people can ask them to reword it or address it so that these statutes are really corrected. Because again, we're so much focused on the here and now, and like, I want it now. It has to be, this immediate society, right? Our devices have to go quicker. Our phones have to be quicker. We have to have on-demand TV. We have to have oil changes that are quicker. It doesn't matter. Everything's quick, right? And we're doing more with our day, which can be good, but it can be bad. And we want to make sure that we're not only addressing the problem that exists in the here and now, but what about the next pandemic? And I don't say that lightly. I mean, COVID exists. I've seen and I've talked to medical experts that have explained in precise medical detail that I don't fully understand about what those molecules and spores look like. I get it. It's real, but we're going to experience many other things like this going forward. And we already have, you know, whether it's the bubonic plague or whether it's SARS or whether it's, you know, HIV or, you know, COVID or anything. The EEE was a big thing in Michigan a year and a half ago. No matter what it is, we need to make sure that these statutes and that 1976 Emergency Management Act cannot be used again to control the people here in Michigan. So that's my 2 cents. The other point I wanted to pull attention to is somebody had mentioned somewhere, and it flipped, I can't see it now, about ways to donate. And I do appreciate that. Whether you guys hear from me or not, I guarantee you, still fighting hard every day for our freedom. No matter where I live, where I go, you know, how old my kids might get, until my dying day, I can almost guarantee you that until my dying day, I will definitely be fighting for our freedom. So any of you who would like to help and donate, our website has listed all the ways that you can do that. There's Square and PayPal and credit card and check and cash options. And whether it's $5 because that's just all you have or feel compelled to share, or whether it's more than that, whether it's a one-time thing or on a regular basis, I really would appreciate that, because even though we're going to be downsizing now that our older 3 kids are all done with high school, you know, I still have a lot of law school debt to pay, and we still need to eat. And I'm not bringing in, you know, regular income while I'm doing this fight for freedom. So, and my entire firm is now focused solely on this. So with that being said, if you are looking for those ways to donate and don't see a link by comment or anything, it is restorefreedomkh.com, restorefreedom, K as in Catherine, H as in Henry.com. And I do hope that I will still have time to do yet a 4th video for you later, where I will answer your constitutional questions. Again, not necessarily be providing personal advice, but to provide you with real, tangible answers about your U.S. and Michigan constitutions and the questions you have for those. So with that being said, I hope you guys have a wonderful evening, and we will see you later.